Well, if anyone still operated under the erroneous assumption that American politicians and bureaucrats would uphold their oaths to protect and defend the U.S. Constitution, Chief Justice John Roberts and the leftists on the Supreme Court just gave them another example of why that's wrong. It's about the right of worship, assembly, and a heck of a lot more. It comes from the formerly liberty-loving Nevada, and it inspires us to wonder how anyone viewed Roberts as supposedly conservative. Hi everyone, I'm Gardner Goldsmith for MRCTV. Well, in a 5-4 decision that might just destroy one's vestigial belief in the integrity of government, Chief Justice John Roberts, July 24th, joined the leftist carousel in its endless stampede against the Bill of Rights. This time, as they did in the May case of South Bay United Pentecostal Church et al. V. Gavin Newsom et al., Roberts, Ginsberg, Sotomayor, Kagan, and Breyer voted against our rights to worship, to freely assemble, to be secure in our property against unwarranted searches and seizures, to due process, our rights against cruel and unusual punishment, against the taking of property without just compensation, and many other fundamental rights, while Alto, Kavanaugh, Gorsuch, and Thomas voted in favor of them. Sort of. The case, called Calvary Chapel, Dayton Valley v. Sisolak, was brought to the Supreme Court of the United States upon appeal after the plaintiff's argument was rejected by the Ninth Circuit Federal Court, and it focused on the unequal COVID-19 occupancy standards forced by the Nevada governor on the rural Calvary Chapel Dayton Valley Church and all other houses of worship in Nevada. The plaintiffs argued, and the Supreme Court dissenters agreed, that Sisolak was unequally applying his executive order by telling churches they could only allow up to 50 individuals into any size house of worship, while casinos, movie theaters, and live venues could admit up to 50% capacity. In a blistering 24-page document, Alto, Thomas, and Kavanaugh offered dissenting opinions, some of which shone a brilliant light on the absolute inequality of Sisolak's edict. And of course, that would be an inequality that is forbidden by the contemporary reading of the 14th Amendment, in addition to being an infringement of the First Amendment. Here's something Gorsuch said. This is a simple case. Under the governor's edict, a 10-screen multiplex may host 500 moviegoers at any time. A casino, too, may cater to hundreds at once, with perhaps 6 people huddled at each craps table here and a similar number gathered around every roulette wheel there. Large numbers of closed quarters are fine in such places, but churches, synagogues, and mosques are banned from admitting more than 50 worshipers, no matter how large the building, how distant the individuals, how many wear face masks, no matter the precautions at all. In Nevada, it seems, it is better to be in entertainment than religion. Well said, and Gorsuch offered additional wisdom. Maybe that is nothing new, but the First Amendment prohibits such obvious discrimination against the exercise of religion. The world we inhabit today, with a pandemic upon us, poses unusual challenges. But there is no world in which the Constitution permits Nevada to favor Caesar's palace over Calvary Chapel. Evidently, Roberts and the SCOTUS majority disagreed. They gave the okay to the governor and his government gang, who seem to think it's no problem to shut down worship and free association, to arbitrarily act like brown shirts and order people around. After all, as Fox News' Caitlin McFall notes about the Nevada government's argument, quote, they said places of worship can permit as many followers as they like for outdoor services. Yeah, you know, outdoor services in the desert and mountains of Nevada. Perhaps it's oversimplifying things, but this kind of fatuous expression from the Sisolak administration almost makes one think they have nothing but utter contempt for the people and their inherent rights. Moreover, the discomfort or danger of a potential option offered by the state is irrelevant when it comes to rights. The state making any decision to shut down a natural right is wrong. And it doesn't matter if they say they're giving you an option. Such an option is forced. It's a non-option, akin to the TSA claiming that you're opting to be groped if you don't want your rights infringed by the radiation scanners. Both so-called options are forced on you, so they're not options at all. Listen to the unwary. Never mistake political compulsion and threats of arrest and fines as choices. That's a form of Stockholm syndrome, of blind self-defilement. And sadly, as much as one might applaud the dissenters for trying to slap down the Nevada wrong, not every aspect of all the dissents were meritorious. For example, as McFall reports, Justice Brett Kavanaugh wrote this, quote, "In my view, Nevada's discrimination against religious services violates the Constitution," which is right. But he added this. To be clear, a state's closing or reopening plan may subject religious organizations to the same limits as secular organizations. And in light of the devastating COVID-19 pandemic, those limits may be very strict. But Kavanaugh has it wrong from the outset. The very concept of those limits is baseless, found nowhere in the U.S. Constitution nor in the Nevada Constitution. In fact, Section 4 of the Nevada Constitution strictly states that the free exercise of religion, quote, shall forever be allowed, end quote, in the state. Perhaps the governor was too busy fixing his precious face mask to read the document. Regardless, the majority of the SCOTUS agreed with the governor, and he and his lawyers got away with it, even arguing that they should be given a pass because of that earlier May case, South Bay United Pentecostal Church et al. V. Gavin Newsom, the case in which Roberts again joined the leftists to okay California Governor Gavin Newsom's obnoxious restrictions on churches. But Justice Samuel Alito offered some sharp words to help Sisolak and the majority wake up to how wrong that was, writing, quote, "In South Bay, a church relied on the fact that the California law treated churches less favorably than certain other facilities, such as factories, offices, supermarkets, restaurants, and retail stores. But the law was defended on the ground that in these facilities, unlike in houses of worship, people neither congregate in large groups nor remain in close proximity for extended periods. That cannot be said about the facilities favored in Nevada. In casinos and other facilities granted preferential treatment under the directive, people congregate in large groups and remain in close proximity for extended periods." But again, the key takeaway here is fundamental rights. All of that argumentation is irrelevant when it comes to the state infringing on your right to assemble, gather with friends, engage in business, or worship God. And of course, as we've seen with politicians and pop news parrots excoriating Americans for trying to open their small businesses or even go to church, even as those politicians and pop news parrots praise or join leftists clustering for protests and what they call peaceful riots, whatever those are, it seems that this overblown pandemic passes over gatherings favored by the left. It seems as if it's a politically selective pathogen, which is seemingly the case with many politicians and Supreme Court justices. Pathogenic indeed. Definitely pathogenic when it comes to your rights. Thanks so much for joining me, everybody. Don't forget, like and subscribe if you're watching on YouTube. Please share these to help circumvent some of the censorious algorithms out there on social media. That's my symbol for censorious algorithms. And head over to MRCTV.org to find out what the whole team is doing. I'll see you in the comments, see you over on Facebook, see you in social media. For MRCTV, I'm Gardner Goldsmith.